Good afternoon and welcome to Data Protection, the GDPR and the opportunity beyond opportunity for consultants. This will be presented by David Marsh, and my name is Amanda Clark. I'm the Director of Curriculum Development at InTouch Networks, and this presentation is for our Consultant Hub members. So I'd like to welcome you to this webinar. I want to give you, before I ask David to introduce himself, I just want to give you a bit of a breakdown of today's session. It's 60 minutes is the maximum time that we can spend on this webinar. So 40 minutes of that will be David making his presentation around GDPR and the opportunity, and then we'll have a question and answer session for 15 minutes. At the bottom of your screen, you should be able to see a box where you can ask your questions. So if you do have questions, please write them in there, and after David's presentation, I will take the time to sift through those and ask the most popular questions from the audience. At the end of this webinar, you will get a copy of the slides that I have for this, so you'll have the detail that is on the slide, and we'll also send you some other links and attachments that David talked about throughout the presentation. So with that in mind, if there's any technical issues or anything like that, then please try and let me know, and I'll do my best to help behind the scenes and let David get on with his expertise. So David, it's over to you.
Thank you, Amanda, and good afternoon, consultants. I'm pretty sure it's as sunny where you are as it is here. And thank you for joining today's webinar here. And I'm David from OFG, as Amanda said. And what our background on GDPR is we've spent, well, just over 4,000 hours of research, would you believe? And we've worked with more than 2,500 companies, including the regulator, the Information Commissioner's Office, the ICO. So what we're sharing with you is the best practice that we've learned in that time. So if you take just over 2,500 companies from the 5.4 million-ish organisations that there are in the UK, there's still a lot of opportunity out there for everybody, and that's what today's session is about. So you may already know that the GDPR, General Data Protection Regulation, went live on the 25th of May, and it was also 2 years in the making, well actually 2 years and 1 month from when it became European law to when the live button was pressed in the UK. Something alongside it called the Data Protection Bill brought that into UK law. So from the 25th of May, it's actually formally into our part of the law. Now, on the right-hand side of this slide, which says Information Age, that's a bit of research that was done 1 week before the go-live date. And as you can see there on the headline, it's saying that roughly half the businesses in the UK expect to be fined because they're not GDPR ready. Well, the regulator based in Wilmslow has got 400 employees. They've taken on about 200 more for GDPR. So even with the best intentions of what they're trying to do, it will take quite a while to get around all 5.4 million organisations in the UK. But the point being there that the opportunity for you is that half the organisations roughly in the UK do not feel they are ready for GDPR, and that now, of course, we're live on it. So as well as GDPR, there's something else which you may be aware of called the Privacy and Electronic Communications Regulation, or PECA for short. That was brought in 2003, so 15 years later. It's quite a bit out of date now, because that looks at the electronic side of personal data and communications. Its nickname was the Cookies Law, so that's why you're seeing all these cookies popping up when you're going onto websites, but it is a bit beyond that, and in many ways PECA sits above GDPR and takes priority in the way consent is sought and given by consumers. Now, the European regulation that's going to replace that is called e-privacy, and that was due to go live at the same time as GDPR did. That would be even more of a challenge, I think, for our businesses. It hasn't, because it's still in Brussels at the moment while they work out exactly what the content is going to be. But the caveat around e-privacy is it's going to be even tougher than GDPR is, and it does deal with business-to-business personal data as well as the consumer side that GDPR focuses on. So we don't have a date for e-privacy yet, but so until then, we're actually under the Privacy and Electronic Communications Regulation. But if you're consulting with a business and you've not had a look at this yet, it's definitely something to be aware of. Okay, and with GDPR, there's no rubber stamp anywhere yet from the regulator or anybody else that says what compliance is. So if an organization or anybody says to you they're compliant, there's no proven standard against what compliance is at the moment. So what that means is it hasn't been tested in law, and because it's relatively newly been released, GDPR, there is no formal compliance. So when we talk with organizations and we get them ready, that's what we call it. So we give businesses a shield that says GDPR ready on it. So at the moment, there's no such thing as compliance, but as we go forward in the months and years, there certainly will be a standard that's issued by the ICO regulator. So in the meantime, it's all about how much risk a business wants to take. So on the slide in front of you, on the left-hand side, you've got low risk. So if you have a plan, or your organizations and clients you're working with have a plan in place, even if it's not quite 100% right yet, that's low risk. And the regulator is not looking for those sort of businesses to spend their time with. If you're partway through an implementation plan yourself or with a client, the regulator, named Elizabeth Denham, you may know, came out and said, if that's the case, you're implementing your plan, you're not quite there yet, and we've gone beyond the go live date of the 25th of May, then she will have sympathy with that situation. Not quite sure what sympathy means, but it means it's a much lower risk than if you've not done anything, because on the right-hand side, if you have no plan in place or your clients haven't and they haven't done a thing, that is pretty high risk in terms of GDPR and the fines side of it. And again, as you may know, the existing fines under data protection were £500,000 maximum. They're now the equivalent of 17 million or 20 million euros, or 4% of your global turnover. And hence Facebook were getting a little bit excited when the Cambridge Analytica story came out a few months ago, because when you talk about 4% of their global turnover, you're talking well over $1 billion. And at the bottom of that little grid, on low risk, it says start from scratch. So some organizations have done that. Manchester United, for instance, 10 months ago now, wrote to all their fans and said, you must reconsent for us to continue to send you information. We don't know for sure, but we're guessing that roughly 85% of the contacts they have not re-signed or reconsented, possibly because they've not got the emails or they thought they'd do it later, but for whatever reason, they haven't done that. So during the football season, all around the advertising hoardings, if you watched it on telly or been there at Old Trafford, in between the adverts, they're saying, please reconsent. And then for the last half dozen matches of the season, where the managers and substitutes sit in the dugouts, they actually had banners unfolded there, so they'd be on the TV cameras saying, please remember to reconsent in. So you don't have to necessarily do that for existing customers that you have or contacts that you have, but Manchester United have taken virtually no risks there because they've started again. And the other end of it, on the right-hand side, if you're going to carry on as you always have, or your clients are, that's kind of high risk, particularly if the original consent that was given was in one of these tick boxes and it was pre-ticked, that is now illegal. Or it was a consent that said, if you don't do this, we will still send you things, like a negative consent. That from 25th of May is illegal. So if organisations are not changing that again, that they're carrying high risk, because not only would the ICO be looking for that type of thing, but any consumer in Europe can report that organisation to the regulator for not being compliant in terms of that. So in the middle area, again, you may have heard something called legitimate interest. So this is saying, look, if you've been receiving something from an organisation for quite a period of time, and that person has not unsubscribed from you, then there's a legitimate interest. It's in your interest to send it. It's in that person's interest to receive it, and it's not outweighed by their rights under data protection. And if you can answer those three questions positively, then you're very likely to be able to use a legitimate interest to carry on contacting the end users, customers, and clients, as long as every piece of communication gives the option to unsubscribe or opt out. That's a legitimate interest. So very much at the moment with GDPR compliance and PECA, it's what is the risk appetite for that business. And if it's high risk by doing nothing, you're only talking about time then, because eventually something will happen. Or if it's low risk, at the other end, you could stop your business because you're trying to get everything completely right on GDPR and beyond. So just to the right-hand side of that on this slide, you'll see it says best practice line, and that's what we're working to on the guidance we're giving here. Okay, just give you a second to focus on this slide here. We've made these slides reasonably detailed, because you're consultants, you might like a bit of detail, but it's really to give you some reference points so you can go back and get a bit more detail on the things we're saying on this call. So these are the 5 areas that quickly you could determine whether you've got a potential client out there to help with GDPR. So the first one is to look on the website. Now, if you look on the InTouch website, you'll see at the bottom it says privacy notice, and that's what it needs to be called under GDPR. And if you click that, you'll see quite a lot of areas that talk about what happens to your data. So that's under one of the rights we have called the right to be informed, and that's why you've probably, up until the 25th of May and beyond, had thousands of emails from companies saying, here's our privacy notice, because that is right number one of a consumer, so they must let you know what happens to your data. So if that privacy notice is there, great, and it's worth looking to see whether it shows how to complain to the ICO regulator, and if it covers a section for children under 16 who, under GDPR in the UK, are not due to be able to give their consent. The second thing to look for is the pop-up cookies, or at the bottom of the page, is there a cookie policy? Because although that's not GDPR, that is PECA, and that is a requirement under that regulation. And the third thing is, if there are any forms on that website that you fill in, just a general inquiry one, or it's a membership one, or a special offer one, underneath that form, it should have a link to the privacy notice, or it should be saying what that data is going to be used for specifically, how long it's going to be kept, and who it might be shared with. So that 3-point check, if you look at any potential clients that you have on their website and they haven't got those 3 things covered, that's their window to the world, so everybody else can see that, but it's likely that they need your help in terms of becoming GDPR ready. The second one is that quite a lot of organisations in the UK need to be registered for data protection, and if they're not, it's actually a criminal offence. And the reason they need to be registered is that the regulator then knows that that organisation is dealing with quite a lot of personal data. So the top line there under point 2, you can see that's the link that we'll send out. And you can search the ICO's register, and that will tell you whether any client that you're working with or looking to work with, whether they are already registered or not. And the second link is literally a 2 or 3 minute check where it asks some questions, and at the end of it, the outcome will tell you whether that organization needs to be registered for data protection or it does not. Usually 9 out of 10-ish organizations as a guide would need to be registered. And then depending on the sort of organization you are and what you do, that now is either a £40 a year registration, 60, or it's £2,000 for large corporates, that is, by the way. So they're the first two things: quick website check, checking with the regulator's website whether the organization is registered or whether it needs to register. And the third one is, does that client or customer, and they should have this on their privacy notice, who to contact, have either a data protection officer, known as a DPO. So for large and complicated businesses, they need to have one of these. If you haven't got one of these, you can be fined up to 10 million euros and 2% of your global turnover. So for larger organizations or organizations that use customer data as their primary business, credit references agents, for instance, they would need to have a DPO. If you're not one of those organizations, you still have to have a data control, data coordinator, data leader, whatever the title is. There isn't a formal one to have, but somebody that leads on personal data within the organization. Now, if you don't have these people in place, that can be an automatic fine from the regulator. So again, asking that question of any organization will tell you whether they're on the road to being GDPR ready or not. Then the fourth one is that everybody that touches personal data in an operational way in an organization has to have GDPR awareness training. That is a requirement, and the majority of organizations, roughly 70 to 80%, have not done that. So even if your clients or potential clients have done some things towards being GDPR ready, this is one that they may not have done. And again, we or somebody else could help you with that. And that can stand you aside of any other consultants knocking on the door right now. So the fifth one is targeting customers and clients for you. So sometimes there's a misnomer that, hang on, this is all about IT, isn't it? It's all about systems and being hacked and that type of thing. Well, yeah, 10% of it is, but 90% of it is about your people in an organization and what they are doing and your processes, your physical ones, how they work. That's what GDPR is about. So it may or may not surprise you that more than half of the businesses that we work with, our key contact is a HR leader. And then around 20% of the businesses that we work with are procurement, that they head on procurement because they have an awful lot of suppliers. So if you've got anything from 1 to thousands of suppliers, from the 25th of May, that organization, you are now responsible for checking that your suppliers are compliant or as compliant as they can be under GDPR. So if anything goes wrong down the supply chain with an organization that you share personal data with, you are jointly and severally responsible now for that breach of data. So it's a requirement to check that your suppliers are as compliant as they can be as well, so hence procurement. And then with customer services and sales, they are about 10% of the organizations we work with, they are the lead because they have first contact with customers. Then in the middle, we have marketing. And if they're the marketing organization or function that contacts customers in any way, then in quite a lot of organizations, it makes sense for them to lead on GDPR. Now, if you have a data protection officer, which is in number 3, because you've got a large point number 3, you've got a large organization, it's complex, or it uses a lot of personal data, then that DPO, that data protection officer, cannot have a conflict of interest. So it can't be your financial director, it can't be your marketing director, it can't be your IT director. It has to be somebody that does not have a conflict of interest within the business. So many organizations outsource that. And again, if you're consulting and it's attractive to you, organizations that outsource are paying roughly £60,000 for an outsourced DPO or data protection officer at the moment. So those 5 things, that website check, looking on the ICO website in terms of whether the customer is registered or needs to be registered, do they have a data protection officer or a data, whatever the title is used, like a coordinator, a leader, because I say there's no particular title you have to have outside a data protection officer. If the organization doesn't have that, then they can be fined immediately. The awareness training would give you an edge because not every organization or consultant that's helping and supporting businesses on GDPR have done that. And then the targeting of who to target within a client's business. It's not usually IT, it's more HR, marketing, procurement, customer services, and sales. So I hope that helps you in terms of if you've got some clients you want to break into, how to do it and who to contact. Now, from our 4,000 hours of research that we've done, and the 2,500 or just over companies we've worked with, including the regulator, these are the 12 points, our 12-point check, if you like, for an organization that when we go in to work with them, once these are all turned green and they're in place, you're as far to, you're not, it says they're 90%, it's 90% plus for sure, towards being GDPR ready and probably whatever compliance will be when that comes out as a requirement from the regulator. So just briefly going to run through those. Number 1, we've already spoken about, which is register with the regulator if you need to. Number 2 is appoint that data protection officer or data controller, data leader, data coordinator. Number 3 is map out where personal data flows from your business. So where it comes in, where it goes through your business, and then where it goes in terms of your suppliers. Because that end-to-end process mapping, when we do it, shocks businesses in terms of how much data they've got, where it's stored, even if they know, and also how much of it is at risk that goes out to third parties. Number 4 is complete a data audit. So after this call, the follow-up email will have 4 attachments, and that's one of them. And that's saying, okay, what data do we hold? What do we use it for? What's the legal basis that we use this data for? In other words, do we use consent to use it? Every new customer you should get consent from. Is it legitimate interest? As long as it's in your interest as a business, the client's interest, and it doesn't impact on end user rights, then legitimate interest might be one of the ways of doing that. Is it contractual? So under the contract or service agreement you have with that customer, that's why you're sharing that data and using it. Is it a legal requirement for HMRC and so on? So that data audit just gives you a view of where all the data is, where it's held, why it's held, and what legal piece is held under. And then number 5 is that there are 8 data subject rights, and this is making sure that the business, if one of those rights is requested, like one of them is called the right of erasure, so you can request that an organization deletes every piece of personal data they've got on you. You can't if it's a mortgage company because you've got a contract with them. But subject to a few restrictions around that organization within 1 month, if not faster, would have to delete all that data and confirm to you that they've done that. So as an organization, you need a process to be able to make sure you can do that within that time, record it, and have a bit of an audit trail behind it if you're ever asked to prove that that's what you did. Number 6, have a privacy notice, or privacy policy is your overall organizational approach to data protection. The notice is the one that you have on your website. So again, one of the attachments on the email that we'll send out afterwards will be a template for that privacy notice. And in there are some areas highlighted in yellow where you can put the client's details in. And that's been signed off by our company solicitor. And yeah, we've got several thousand organizations using that template. So please feel free to help yourself to that one. And it also says after that employee privacy notice. So this is under that right to be informed, and that's why the privacy notice goes out to end users. But also your employees have the same right. So your client's employees have the same right. So there's the equivalent privacy notice that needs to be sent to the employees if it hasn't already. And again, we'll send that as an attachment on the email after this call. So there you go. Number 7, ensure online and offline customer filled forms are compliant. What that means is it either has to link to the privacy notice, which explains what happens to data, or underneath that form, it has to say what the data is going to be used for specifically and can't be used for anything else, by the way, how long it's going to be kept for, 12 months, 24 months, 36 months, or until you unsubscribe perhaps, and any third parties that you share that data with. Best practice you'd have to put ABC Limited, if it's a courier service, for instance, or acceptable practice is that you put with courier and delivery companies. That's perfectly acceptable. But somewhere on a form, on a website, or on a paper-filled form, it has to reference those things, either directly on the form or linked to the privacy notice where that's covered. So number 7, we've just spoken about those customer field forms. Number 8 is train your staff. I mentioned that earlier. So that is a requirement under GDPR. Anybody that touches or handles personal data does need to have awareness training. Now, of course, there's no standard on that as yet, but that needs to be audited with a record of who was trained, when they were trained, and what they were trained on. That training goes from about £25 per person if you want to do it online, or take your choice. There are many training organizations, and again, if you want an introduction to anybody, we don't get anything for doing that, by the way. There's no problem to do that for you. Number 9 is add the GDPR responsibilities and routines to your employee and staff policies. This is missed by many organizations. They map everything out, but they forget to write down the policies and procedures that the employees should be following. A bit like health and safety, really. It follows the same format. And then you've got a reference document if you get some wrong behavior amongst employees with personal data. You've got a reference back where you can do whatever you need to do in terms of your own organizational processes. Number 10 is also an attachment, one of the 4 attachments that will come out on the email. This is called assessing any future projects. It's called data protection by design, and there's a form called a data protection impact analysis, which means that before you start any future projects that have new technology in them, or there is a potential risk to people's personal data, it is a legal requirement under GDPR that this form is completed, DPIA. So again, that's an attachment that we sent. It doesn't have to be done retrospectively. It's for any new projects that your clients are going to do in the future. Then number 11 is about creating an incident and breach reporting log. This is the 4th attachment. Again, you have to have this. A bit like health and safety, again, this one. So if there's an incident, so an incident is 99 pieces of data, which are name, address, telephone number, and email, get lost on a memory stick. By the way, if any memory sticks are used, please get people to put at least a password on them or encrypt them, because that's then not an incident. But if it's not password protected or encrypted, that becomes an incident and has to be recorded as such. 100 pieces of data like that, or one piece of what they call special data, which could be name, address, telephone number, email address, and then you've got some medical details, even the football club that person follows, anything that helps you profile that individual is categorized as special data. One of those that's lost, and that is a breach that you have to report to the regulator within 48 hours of being aware of it. So again, if you have password protection on any devices or laptops that you use, or ideally encryption, you do not have to report that as a breach. But nevertheless, that fourth attachment is that document that can help you with that. And the 12th bit we've spoken about already, which are check that your suppliers, as much as you can, are as compliant as they can be. And we are developing some software. If anybody wants to help us beta trial that, it's been through alpha trials. That sends the right questions along to the suppliers, and from the response, you can actually grade that supplier's high, medium, or low risk in terms of GDPR. So those 12 things, if you or your organizations that you work with or want to work with your clients, if you have those things in place, you are as compliant as you can be at this stage. Okay, Amanda, so that's
fantastic.
In terms of GDPR, in terms of GDPR, that's the overview.
Thank you very much for that, David. And we've had a few questions streaming in. So one of the first questions is around how it applies, how much of what you've been talking about actually applies to local government. And a similar question, how does it apply to charities? How much of it applies to charities? Could you give any overview or more specifics on that?
Yes, actually it applies to every organisation that has got one piece of personal data, and on any EU citizen, by the way. So even if you're sending something to somebody at their work email address, so mine is david.marsh@ofglimited.com, that's personal data. If it just said D or David, it's not necessarily personal because you can't identify who I am. So for charities, they are treated in terms of GDPR like anybody else. And if you go onto the website of the Information Commissioner's Office, ICO, and have a look at action they've taken, you don't have to get down many pages before you'll see, sadly, a number of charities that have been fined under the old data protection regulations, mainly because they've been, if somebody's given a substantial donation, they profiled that person and passed it on to other charities to contact that person. Well, that's illegal. So with charities, it's exactly the same. With local government, local government have to have a data protection officer, no matter what size they are, and councils as well. Also, they're not allowed to use legitimate interest. They have to get consent from anybody that they're sending information. Unless it's contractual or legal, they have to get consent from that individual. Otherwise, it's exactly the same as everybody else.
Okay, fantastic. So it applies to everyone, and actually that links very nicely to a question that's been asked on, do I need to be registered as an individual who is running a business? So as a consultant, do I need to be registered with the regulator following that link that you've just said there?
That's a great question. If you have premises with CCTV on them, outside CCTV, you have to register, no matter who you are. Actually, if you're an individual and you not in business, if you're an individual consumer and you have CCTV at home outside, you have to register. Other than that, the second link that we're showing for the ICO on that slide, Amanda, is a 3-minute check on whether you need to register or not. If you're running things like a membership scheme, you will have to. But if it's I was going to say run of the mill, but if you're working in terms of you've got customers and you've got accounts and information and they buy from you and you trade with them, you may not have to register, but it's worth that 3-minute test or so on the website, and that will confirm one way or the other.
Fantastic. So if you're unsure, go to the website, go to
Yep.
that link on the website, and just do the 3-minute test, and you'll know whether you need to or not. A good question around that CCTV that you talked about as well, because I know that's affected quite a lot of individuals. And I actually saw one of my contacts posted something on LinkedIn and just said, well, they've got one of their friends has got a CCTV in their back garden because of burglaries previously. It's a locked gate. All you can see is the actual garden. Do they need CCTV? Which I thought was a really interesting question.
The answer is yes. They have to register.
Yeah.
Because it's potentially recording people's image, which is a personal data. Ironically, inside the house on the webcams, and even the Ring doorbell, the video, you don't have to. If it's a business, by the way, you have to have signage up that says you are being monitored by CCTV, and you have to put contact details of who that person can contact if they want to view it or ask for it to be deleted. They are the new rights that we have under, they're not new, but the rights we have under GDPR.
Fantastic. Thank you very much.
On the last one, Amanda, where we're talking about do we need to register with the ICO, you can do it voluntarily if you want to. It's £40 for most businesses, and if you don't have to, you don't have to, but some people do. Because they see that as an advantage when they're going to their customers to say that they are registered.
Excellent, to get a competitive advantage. Yeah.
Yeah.
Yeah, I guess that gives some security as well to the to some customers, some clients.
Yeah.
So, okay, and really good question here it says I'm advertising a 2-day workshop and inviting people to attend. I want to keep their data for future training courses. Do I need a privacy notice, and should I register with the ICO?
Yes, you need a privacy notice to say what happens to that data. Best practice is you've got a little box under that form that says tick here if you'd like to receive the occasional update and special offer. Second best practice is you include that by saying, we're looking forward to you coming to the event, and we'll continue to send you special offers and information we think will be of interest. Please unsubscribe if you don't want this. But it will need to link to a privacy notice, and that one that we're going to send out afterwards, Amanda, if folks could literally put their company details in that, or their details in that will suffice.
Okay, excellent. Thank you very much. Another question then. Gosh, we have quite a few. We've got 6 in a row now, so we may not get through all of the questions in the time we have available, but obviously we'll do our best. But the next question is, some clients I've seen have complex siloed data systems which can take many years to fix and consequently make manageable. How have you approached this type of scenario?
Yeah, so with some organizations who we've been working with, they've wiped them because they found that data is well out of date. So one of the rights we have as individuals is that the information kept on us is accurate. The Dorset accent coming out there is accurate. And if it's not, that you could be in a little bit of trouble if you're not updating your contact details with a customer. So at one end, people are getting rid of them. At the other side, people, organisations we're working with, have sent almost a reintroduction email to say, hi, we haven't heard from you for a while. Just wondered if you're still, you're still interested, or, we'd like to send you bits of updates or special offers. And you can either put a consent box under that or the unsubscribe piece underneath. But that first one, I'd recommend you not selling anything to that customer, because if you do, they could make a complaint. But if it's a introduction email and you give the option to unsubscribe, you're on the right side of best practice there.
Okay, excellent. So we'll see lots more emails coming through, I guess, over if you're telling everyone else that. So in terms of, there's another question here around suppliers, verifying suppliers. So how far do you have to go in verifying their compliance, suppliers' compliance? Does it need to be a simple question, a detailed questionnaire, an audit? And following on from that, do you need to do an annual reconfirmation of that information? So how does that work in terms of verifying your suppliers?
Yeah, they're great questions, they are. Yes, the recommendation is that annually the suppliers are rechecked. And again, we've seen anything from an email that says, could you confirm you're GDPR compliant? Well, there's no such thing, but there isn't yet. Can you confirm that you're GDPR ready? And either there's no response, there's a yes or a no response. So that's not really very helpful. So it's usually a couple of questions. And what we can do, Amanda, if it helps, is put together half a dozen questions and send them out to folks on the webinar as guidance. But you're asking things like, have you, those 12 things really, but the 6 of them probably, have you appointed either a data protection officer or a data controller, sorry, a data leader or a data coordinator in your business? And if the answer is no, they are uncompliant.
Okay, even in very small businesses.
Even in very small businesses, you have to have somebody that the regulator can knock on the door and ask for, if that makes sense. By the way, if your clients are using computer providers and backup systems outside of the EU, those organizations have to be GDPR compliant, and they also have to have somebody based in the EU that the local regulator can work with if they need to. So we'll send half a dozen questions which cover those things. Fantastic.
That's really good. Very generous of you, David, as well.
Well,
actually, what you've just said there follows on with another question that's come up about all EU countries operate with the equivalent of the ICO. So is the registration process embedded in GDPR, or is it a UK-specific requirement from the ICO?
Yeah, so all EU or EEA, they call it, the European Economic Area, all of those countries have to have the equivalent regulator. And the difference is that in the UK, for instance, we have a regulator, but we have the Data Protection Bill, which translates the European one into UK language. So depending on the country and the way they operate, there are some small changes. So for instance, some countries will say that Ireland, for instance, I think, Scotland, that children under 13 cannot give consent, but over 13 they can. And the EU regulation says under 16. So you get slight differences with local law on that. Yeah.
By different countries, but they've got the equivalent of an ICO
in
each European country.
Yeah.
Okay, fantastic. Excellent. Another question then. Wow, we really are getting lots of questions here. What should recruitment companies consider with reference to GDPR? And that's a good question because they're passing on personal information, I guess, in terms of CVs and etc. So, which could be identified. I guess there's a lot more, but I'll leave that to you to answer that.
Yeah, completely. So whoever that CV is sent to or receives it, the first organisation to receive it. So, for instance, if it's on the Indeed website, job website, they will be responsible for the first part of GDPR. And in there, either in their privacy notice or on the CV part where that form's uploaded, it has to say what they're going to use that information for, how long they're going to keep it, and who they're going to share it with. Mm-hmm. And as that comes down the line, if you've had that from an online recruitment site and it comes into your business, you then have to live by the commitments that original receiver has given. And that's why that supplier check is quite important, if you know what I mean. Mm-hmm. Yeah. Also with CVs, quite a lot of them still are on paper. So you could have an electronic process for how long you keep CVs, what they're used for, and so on, and a paper one as well. And with the end user, the person that supplied it, your options are to either specify how long you're going to keep it, so we'll keep it for 6 months to look for other opportunities for you, and then we'll destroy it, or we'll keep the CV until you tell us that you don't want us to keep it anymore, unsubscribe or opt out. The first one is best practice. The second one is acceptable practice. Mm-hmm. But it's also comes under what the ICO called special data category or special category data. So if that got into the open market or got stolen out the back of somebody's car, either in paper or electronic format, you have to report that as a breach, unless the electronic format is at least password protected or encrypted. Mm-hmm. But yeah, if a CV flies out the back of your car on the motorway when you've opened the door, you have to report that as a breach.
Right, or leave it on the train.
Or leave it on the train. Yes, that's right. And again, if people can be bothered or they're interested, and you go onto the ICO website and it says action we've taken, you'll see police forces, local councils, etc., who are being fined £100,000, £250,000. Bearing in mind the maximum on that was 500 at the time, for losing one piece of paper with case-sensitive information on it.
Okay, yeah, fantastic. I suppose there's a lot to do with specific types of businesses as well. There's a lot of different considerations to be made depending on the business. We've got another question here around somebody that assists a number of private landlords where they don't use agents to let their properties. They seek references from their prospective tenants. Do private landlords need to provide a GDPR statement to prospective tenants either before the tenancy agreement or within the tenancy agreement itself, which would, of course, be after the fact?
Yes, so it would be at the front end when any information is shared from the tenant. There would need to be a privacy notice that covers that tenant can access. That's the right of access, the first right we have as consumers, to access what happens to their data. So, yes.
You would need to give that up front, basically.
You would, and that it's 90-odd% certain that landlord would have to register for data protection with the regulator.
Oh, really? Right. Okay. So
they can do the test, but yeah, you're asking for information that is what they call special category data. So you're asking things like how much you earn, perhaps, what your bank details, or you take credit card payments.
Yeah, or some kind of ID and that kind of thing.
Yes. Yeah.
Okay, fantastic. And still, we've got a few questions, and if we don't get through all of the questions, because we do have to stop at 1 p.m., if we don't get through all of the questions, we will answer those separately to the whole group when you get a copy of the slides. But the next question is, given a retrospective claim culture, do you have any recommendations for determining data retention periods?
Whoa, that is a great question. So what we are seeing right now is the PPI companies, because PPI runs out next August, are starting to make moves into data protection, and they're looking for opportunities where there's been a breach or data's been misused, and likely to go after class actions for large companies to begin with. But there could be the no fee and no win, no fee situation. So you've got two threats, if you like. You've got a complaint to the ICO regulator, who will investigate that, or you've got a direct. If you've misused data, you can be sued by that person, and you've got the PPI companies behind that. So with the retention period, I think it's a black or white one. It's either going to be 12 months or 24. There's a specified term that you give. And please, please, please don't go a day beyond that and send something out to that consumer, because that's what some people will be looking for. Or it's, we will keep in contact until you unsubscribe. And because none of this has been tested in court yet, that's considered to be, both of those are considered to be low risk. So if you're asking in general what the companies do, they say, we'll keep you informed until you unsubscribe.
Okay. Fantastic. Yes, I'm seeing a lot of that on the things I get. Excellent. All right. I guess a personal question here someone has. I keep receiving text messages from organisations without opt-out options on the text messages. Is this a breach of GDPR?
So that was without opt-out?
Yes, so you're getting text messages, and yes, I've had this myself. You get a text message, you can't answer it, or you can only answer one way. So they've made it impossible for you to stop or unsubscribe. Is that a breach of GDPR? Yeah,
it's a breach of PECA as well. That says you are not able to send unsolicited electronic communications. Ironically, you can post something to somebody. That's not covered by any of this. How weird is that? But yeah, so they are. That is illegal. Whether it's under PECA and some elements are under GDPR. The ICO investigate both PECA and GDPR situations. Now, you can go onto their website. If you search "make a complaint," or I think it says "make a complaint," it's going to take you probably 3 or 4 minutes to fill in a form about that organisation. So if all you've got is a contact number, or that's enough. You don't even get that, do you? But it's going to take you 3 or 4 minutes on the website to do that, to report it. Yeah, and all you would need is the email address and or mobile number, whatever, if it comes up. That's all you need to provide. Fantastic. Okay. And there's a question here from the legal sector. Can I contact former clients about relevant new services? I guess that depends on how long ago that former client was. Yeah. So if you originally had consent, which wasn't a pre-ticked tick box, or was, if you don't tick this, we're going to contact you anyway type thing. So as long as it's GDPR compliant in terms of that, you're fine, you can carry on. If you've not had consent, we're then using legitimate interest. So we're saying, and the word the regulator uses is surprise. So would it be a surprise if that person received that contact from you? So if you're selling In Touch memberships, and then suddenly you're trying to sell us car insurance without our consent, you're not allowed to do that. But if you're selling In Touch memberships and then you're selling associated events with that, one of the benefits of membership, if you like, then under legitimate interest, that's in your interest to do it. It's in my interest to receive it as a member, and you're not taking away any of my rights to do that. So, and I can always unsubscribe.
So we're not sharing the information with the suppliers. We're just sharing the suppliers' information with them. That's okay. So for our members, there are certain things we think that will be of value to our members. We'll share that.
Yes, because I can always unsubscribe.
Yes, and it's not going to them. It's going through our system.
Yeah. On the caveat from what you said there, Amanda, as well, is if that data is more than 3 years old, or you have not contacted that person in the last 12 to 18 months, you should seriously ask yourself whether it's still accurate data. Because if it's not, then we shouldn't. You'll get the bounce back anyway. But if it's email, but we shouldn't be. And anything over 3 years, you just need to seriously ask yourself: is this still relevant for the end user and for me?
I guess for somebody in the legal sector, from what this is referring to, it could be more than 3 years that you've had contact with that person that's on your database, and they've come to you for, let's say, house buying, but now you offer another service for car accidents or whatever it might be. So I'm using consumer ones there, but you might offer business service, business legal advice, and want to let your other clients know about that. Yeah,
so my counsel on that would be to firstly to send a reintroduction email. Hi, we've not spoken for a little while, but we think we've got some things you'll be interested in, so we'll send you the odd occasional email on that. And then you've got the unsubscribe underneath, or if you don't want this, please unsubscribe. And then your second one can be that sales pitch, if you like.
Okay.
Because using the regulators, is it a surprise? Well, if you've had an introduction email and you've not unsubscribed, that's not really a surprise. But if it comes out of the blue after 3, 4, or 5 years, it could be a surprise.
Yeah. Okay. All right, great. I think there's a few more questions, and we're not going to get through all of the questions now, given the time that we've got available. So just a very quick answer to this, David. As an outsourced psychological services, on behalf of the military and police, where are the responsibilities for the outsourced company as opposed to the primary client? I guess that's based on delivery as well, method.
Yeah, so you get you're either called a data controller or a data processor as an organization. The data controller is the organization that makes decisions on what happens to that data. So they're always the lead organization, and the processor is the organization that carries out those instructions. Now, this sounds very much like it would be that special category data, because you can profile people from it. So you have to be more sensitive about that. But if you're the data controller and you're making decisions about it, you'd have to follow all of the GDPR guidance that we've given.
Okay.
If you're a data processor, you still have to be, do the right things, but you're reliant on the information and what's given you from the data controller. That makes sense.
Yeah. Okay. So it's working out where you fit into that process. And I want just a yes or no answer to this one, David.
Okay.
If I wrote a letter to someone, I know offering services, does this fall under GDPR? I think I know the answer anyway. Yes or no? Yes, it does.
Yes.
Okay, thank you very much for that. There's a couple of other questions that we'll look to answer at another time. I'm just aware that we've come to the end of our time together. Thank you very much, David. Really appreciate you sharing your knowledge and expertise with us. And the contact details are on the slides for anybody that needs to get in contact with David. And also for our Consultant Hub members, we have some other free webinars scheduled over the course of the next few months. The next one is the challenges of a consultancy career, from an In Touch member who has really gone full out in terms of pushing forward on his consultancy portfolio career, Phil Birch, and I'll be joined by him on the 17th of July. In August, we'll be looking at mergers and acquisitions, and the others are listed there. Thank you very much indeed for your participation. I would ask you if to please give us feedback on this from the star rating that you can see on the software here. That will be very useful to us. And a copy of this recording of this webinar will be forwarded to those people that are registered for the event. Thank you very much, ladies and gentlemen.